Hello and welcome to All Indians Matter. I am Ashraf Engineer. No poaching agreements between industry competitors are becoming increasingly common, and clauses that forbid employees from moving to competitors are frequently worked into employment contracts. This has been criticized because it serves to artificially depress salaries and sucks away competition from the talent market, enabling rich corporations to get even richer on the backs of their employees. Are such clauses legal? Even if are they ethical? And how do they affect salaried employees?
All Indians matter.
We have on the show Shahezad Kazi, a partner at SNR Associates, a full service law firm mostly advising international clients and Indian listed and multinational companies. Shahezad primarily practices in courts and tribunals in Mumbai, but frequently appears before them across India too. He also regularly appears in domestic and international arbitrations. His area of specialization includes commercial disputes, shareholder and other corporate disputes, insolvency laws, securities law, regulatory investigations, and enforcement of domestic and foreign decrees and awards. Shehzad is a graduate of the Government Law College Mumbai and was the recipient of the Legal Era 40 Under 40 Rising Star Award last year. Welcome, Shehzad.
Hi, Ashraf. Thank you for the kind introduction.
Shehzad, how common are such no poaching agreements and related clauses in employee contracts?
So, these are two separate concepts. First, we must understand that no poaching, I think it's a agreement between, say, two organizations who essentially act as employers. One organization telling the other, and vice versa, that we will not hire employees from the other organization. From clauses which restrict an employee from joining a competitive organization or a competitor. So this has to be first understood. As far as no poaching agreements between organizations and employers is concerned, really we've not, in my practice at least, I have not come across two organizations so openly entering into such agreements, or even behind closed doors. We've not seen any sort of litigation or dispute on these sort of agreements. But as far as these clauses which restrain an employee from joining competitors is concerned, those are fairly common in employment contracts. And, you will find those clauses almost in every employment contract, if I may say so. Now, what matters is what is the degree of restriction. And these clauses or agreements are typically referred to as restrictive covenants. Now, the extent of the restriction determines whether these clauses are enforceable or not enforceable.
Right. But are they legal in India, Shehzad? Because I know that they aren't in many parts of the West, for example.
So, as far as the statute is concerned, there is no express prohibition under any law which prevents either sort of agreements, the one between employer and one between an employer and employee. The genesis of when they become legal and when they become illegal, or I think the right word would be when they become enforceable and when they don't become enforceable, stems from Section 27 of the Indian Contract Act, which is basically the principal legislation for all agreements and contracts which are entered into in India. Now, what Section 27 says is that agreements in restraint of trade and commerce shall be void. Now, taking an extension from that, if an employer agrees into a contract with an employee which entirely prohibits him or her from joining a competitor in the trade or commerce which he or she has been trained all her life and from which he or she can derive livelihood, those are the kind of agreements that are not enforceable. There is one exception to that rule, is suppose I have entered into this agreement after having received consideration for as goodwill for selling my business or selling my enterprise, then these agreements can be enforced.
Yeah, so if I understand it right, just to put it in layman's terms, what you're saying is that if it's a regular clause that is going to prevent you from making a living, then that's not enforceable. But if I've sold you my business and part of the deal of selling you my business is that I do not leave and then become CEO of, let's say, a competing organization, then that's enforceable, is what you're saying. But at a lower level, Shahzad, one is, of course, the legality of it. What about the ethicality of it and the fair play part of it? What are your views on the matter?
So, there's this very, I think, famous saying that what is legal may necessarily not be moral or ethical, and what may be moral may necessarily not be legal. I think it's very true when we look at sort of certain clauses in most laws. My view is that certain restraint is necessary when it comes to regulating employer employee future relationships. And I'm meaning future is when they part away from each other. Because when they are together, when they have the employer employee relationship, then those are clearly covered by contract, enforceable, they are within the reach of each other, etc. But what matters is when they leave the organizations, what is that they do or what is that they expect the other to do. In my experience, I have seen organizations who act as dictators. I've seen employees who go rogue. So it really depends on the facts of each case. Some regulation, according to me, is necessary. I think, there needs to be a difference between free competition and free for all competition. I think, there is a need for regulation in India as far as this is concerned.
Shazad, in many cases, such clauses are introduced into the employment contracts of low and mid level workers also. How is this even justified?
So, frankly, Ashraf, what I've seen is every company or most companies have standard templates of employment agreements. It's only, the agreements that are entered into at the most highest level. Those are sort of, drafts are shared with the employee. There is some, back and forth on the clauses, etc. But as far as low level, mid level, or other employees are concerned, you really need to sign the standard format. When you sign agreements or when agreements are sent to prospective employees, nobody reads them. Just the HR just sends it because it's the format of the company. So really, there is no thought process that goes into each and every employment agreement. Uh, Certain clauses are there because they have been historically there. No, I mean, even if these clauses are there in an agreement, whether they are enforced or not, that's an entirely different matter.
I'm glad you raised this point, because when it comes to extremely senior level appointments, I'm going to come to that in 1 second. But before that, when I was researching this episode, I read that in some cases, these low level workers can't even join a franchise of the same chain. Their contracts contain that clause, leave alone a competitor. So, how do you react to that?
The way I look at it, Ashraf, is that you have to, although it may be a franchisee, you have to look at who the employer is, because the way franchises works are that suppose you and I want to say set up a franchise for a popular food chain, then you and I will get apply to the food chain, get a license, we'll have a space. Then you and I, in our individual capacities, will hire employees to work at the franchisee. So, really speaking, the employer in those cases are not the food chain agency or the company. It is you and I who are the franchisee, and it is you and I who enter into those sort of agreements which prevent an employee from joining the other organization. So you have to look at it from who the employer is perspective rather than, say that the franchisor is preventing its employees from, shuffling between the franchisees.
Yeah. So let's come back to that senior level appointment bit that we talked about earlier. So, of course, many say that the argument can be made to include such clauses in the contracts of very senior staff, so CEOs, MDs, etc., because they have access to sensitive company information. So, I mean, could you talk a little bit about that? What's your view and how does that
So I
work?
think access to information has to be distinguished from having access to information. I think at a senior level, you have a formal access to certain information which may be confidential. Whereas at a low level, you may get access to confidential information, although you may not be entitled to it. For example, when a group of employees sit for lunch together, one may have formal access to the information and then he shares it with the other employees, because they're at a friendly level or whatever the reason might be. They have access to the confidential information. It is not true that only the senior level employees have access to confidential information. Like, for example, an executive at a bank may have access to the contact details of the top 10 customers he's interacting with, etc. The moment he switches employment with another bank, he then contacts that customer to say, "Oh, I have come here. Why don't you open an account here, etc." So I think it is a misnomer that only employees at the highest level have access to confidential information. Senior level employees have formal access, low level employees have informal access. I think that is how you should look at things.
When it comes to such clauses, and let's look at ones that are enforced right now, what impact do they have on long term earnings and career graphs of salaried employees?
Yeah. So as I said earlier, Ashraf, there is no formal specific legislation as far as this is concerned. These the enforcement of these clauses really depend on what is the restriction, how serious it is, and to what extent the employee is restricted from gaining access to livelihood. As far as enforcement is concerned, I think India is considered, and even in my experience, is a very friendly employee jurisdiction. In the first instance, there are no clear laws which really restrain employees. Second, even when you go to enforce certain clauses in courts, the courts have a very sympathetic approach towards employees. Injuncting employees or preventing them from joining a competitive organization, etc., is rarely seen.
The whole point of a free market, Shahzad, is to have fair competition in all aspects of it. That includes talent attraction and retention. So, I mean, there's a point of view that such clauses are also anti free market. What's your point of view?
Yeah. So my take on that, Ashraf, is that, as I said earlier, you will find these clauses in pretty much all contracts, but not in all cases these are enforced by the companies. Now, you know what I have seen in my practice is, suppose there is a situation where the breach by an employee is so grave and is impacting the ex-employer to such a large extent that the employer is taking the risk of fighting a litigation in a jurisdiction where, number one, there is no clear legislation on this. Number two, the courts have a soft corner to employees. I think those are the kind of cases where these sort of clauses are attempted to be enforced in courts. And I said earlier, courts are very, very hesitant or reluctant to pass orders against employees.
Yeah. Yeah. I think that's what you've been saying again and again. It's very tough to enforce such a contract, even though you may have signed it. But let's say an employee finds that they have unwittingly signed a contract. As you said, nobody really looks at the fine print. You probably look at your salary and stuff like that, and you sign a contract. What can they do to remedy the situation? Let's say they are prevented from working for a competition. They need to find a way out.
So, Ashraf, contract by definition under Indian law is an agreement which is enforceable. The moment you say that I did not know what I signed, it means that there was no meeting of minds. You are challenging the very basis of your arrangement with your employer. You're going back in time to say that, look, I never knew what I signed, and therefore my employment itself is invalid. So I think having signed the agreement, having worked for an employer, say for 3 months, 3 years, 30 years, an employee cannot say that, look, I signed something without reading. So signing a contract unwittingly, I don't think so. That sort of defense can be taken by an employee when it comes to, say, a litigation in that regard.
Sure. But what is the remedial option before that employee? If it's not litigation, or is there any option at all?
So I think number one, he can't say that he didn't read the agreement. What he can say though is, look, the restraint against me in the agreement is so wide and has such a huge impact on me that I am prevented from gaining livelihood by performing a trade or commerce which I have trained myself to do over a period of time. That is the argument that he can
Yeah.
raise.
And as you said, courts are reluctant to then rebuff that argument. And what's the government institution or ministry that would deal with such matters? Is it the Competition Commission or something else?
A competition commission deals with anti-competitive arrangements between two companies, and when such arrangements have sort of adverse impact on competition. So far, I have not seen the Competition Commission of India getting into action because of something that they noticed in relation to these no poaching sort of arrangements, or if they exist. But I think the Ministry of Employment and Labor would be the correct ministry from the government's perspective to be looking at issues in relation to this.
Right. And have you had any litigation of this sort ever come across? Have you ever come across such litigation in your practice?
There has been litigation where uh, employers want employees not to join a particular organization. Employers have said that you are holding certain information which is confidential to the company, which in the hands of the competitor can be misused, or you've already misused it. And so there has been litigation. I would say there is no litigation, but those are very handful of cases.
And is there any particular industry where you find such clauses to be more common, or is it across sectors? I can tell you, for example, I have a media background, and it's certainly pretty common there.
I would not say that they are common in a particular sector, but I think I would say that the litigation is fought when it comes to employee who has held a high level position.
And so, what would you advise employees when they're signing contracts? Because these clauses are often slipped into contracts. As you said, often it's a standard template, often it's not enforced. At the same time, if an employee is not comfortable signing that, what can they do at the negotiation stage or at the contract stage?
I think employees should certainly read what they are signing or before they sign it. I think it all depends on how desperate an employee is to get employment, and sometimes to, say, work for a particular organization. Because even from an employee perspective, sometimes to work for a particular organization could be one of the very important achievements in his career path. It is, according to me, a commercial decision that an employee takes when he decides to enter into this sort of agreement. The one thing that an employee can do is that when he receives the agreement, if there is certain clause which he is not comfortable with, he can point that clause out to the relevant HR executive who sends him the agreement for signing, and he can record his sort of concern or protest. And if the HR says that, look, this is the standard format, we can't change it for you, then he can go ahead and sign, and then maybe that record will or may help him in any future litigation that he has to go through.
Yeah, so this is a critical point, Shahzad. Thanks for making it. Uh, so, Shahzad, here's a question I ask all my guests at the end of the show: why do you do this work?
It is, I think, for the this. I mean, it's for the passion of law, frankly, because as a lawyer, you don't know which client will come knocking to your door, seeking advice, seeking assistance. Sometimes, you uh, you have an employer knocking at your door. Sometimes it's an employee. Uh, what you need to do is you have to give them the right advice, the right position in law, and it is for them to decide whether they want to pursue it, not pursue it, etc.
Shahzad, thanks so much for shedding light on what is a practice that certainly does generate a lot of debate, and also for sharing solutions and things to watch out for.
Thank you, Ashok.
Thank you all for listening. Please visit allindiansmatter.in, that's ALLINDIANSMATTER.in, for more columns and audio podcasts. You can follow me on Twitter at Ashraf Engineer, that's ASHRAFENGINER, and All Indians Count, that's ALLINDIANSCOUNT. Search for the All Indians Matter page on Facebook. On Instagram, the handle is All Indians Matter. Email me at editor@allindiansmatter.in. Catch you again soon.